lost the job. Yet why can't the pension be stopped? The full story of the bipartite settlement. It was night time. An old employee of a government bank was sitting quietly in his home. The job was gone, the identity had been snatched away, and now the biggest fear stood before him. After a lifetime of service, would even the pension of old age not be given? Family expenses, the need for medicines, household responsibilities, and the worry of tomorrow, everything was standing before him at once. The bank said, if the job is gone, the pension is gone too. But the employee did not give up. The matter first went to the lower courts, then reached the High Court, and finally came to the doors of the Supreme Court. The fear begins here, because if the pension also stops after the job is gone, then what is left with the employee? And the curiosity is born here. What rule was it that made even an employee removed from service entitled to pension? In today's time, losing a job is not a small matter. Earlier, people used to think that if they got a government job or a government bank job, life was secured. But the reality is that whether the job is in the government sector or the private sector, employment can come under threat because of a mistake, indiscipline, dispute, restructuring, or some legal reason. The only difference is that every job has its own service rules, and many times, hidden inside these very rules are things that become a shield for the employee in difficult times. This is not just the story of one employee. This story is important for thousands of bank employees who work hard for years, handle branches, sit at cash counters, face customer pressure, complete targets, and in the end, connect their hopes of retirement security with pension, gratuity, and provident fund. But the question is, if an employee commits serious misconduct, the bank removes him from the job and then says that pension will also not be given, will the employee be left completely empty-handed? The Supreme Court clarified a very important point on this very question. This case is said to be related to a clerk of UCO Bank, Vijay Kumar Handa. The incident was from the year 1998. A dispute took place inside the bank branch, in which the employee was accused of assaulting an officer. The bank management considered this gross misconduct. Gross misconduct means such serious indiscipline, which the organization considers very serious. After this, a charge memo was given to the employee, an inquiry took place, and after the disciplinary process, he was removed from service. But the story did not end here. The real fight began when the question of pension and retirement benefits came forward. The bank tried to stop the employee's pension. The bank's argument was that the misconduct was serious, so the employee should not receive the benefit of pension. On the other hand, the employee said that under the order by which he was removed, the path to superannuation benefits was not closed. Meaning, if pension is due according to the service rules, then it cannot be stopped merely in the name of removal. This dispute slowly traveled through the courts and reached the Supreme Court. Now here, one name becomes very important: bipartite settlement. In simple language, bipartite settlement is an agreement between banks and bank employees' unions, in which service conditions, discipline, punishment, benefits, and many rules related to employees are decided. This is not a casual agreement. Rather, under the framework of the Industrial Disputes Act, it gets legal recognition. So when a provision is included in it, it does not remain just a matter of paper, but becomes legally important for both the bank and the employee. In this case, Clause 6B was discussed the most. According to this clause, if an employee is found guilty of gross misconduct, he can be removed from service, but that removal can be with superannuation benefits. Superannuation benefits can include benefits like pension, provident fund, and gratuity, which are otherwise due to the employee according to the rules. The Supreme Court considered the interpretation of this clause important and said that if the employee is otherwise eligible for pension, then pension does not automatically end merely on the basis of removal. One thing needs to be understood very carefully here. This does not mean that any employee can commit misconduct and still receive pension unconditionally. Absolutely not. The Supreme Court's point was that if the punishment order has removed the employee with superannuation benefits and the employee has completed the required service to receive pension, then the bank cannot deprive him of pension. Meaning, the decision does not justify misconduct, but explains that punishment and retirement benefits must be read separately according to the rules. Usually, in pension rules for bank employees, qualifying service is very important. In many cases, it is necessary to complete the minimum eligible service. If the employee has not completed the required service at all, then pension cannot be claimed simply by taking the name of Clause 6B. The Supreme Court also clarified this point that only those benefits will be given which are otherwise due under the rules or regulations. Meaning, pension is not an automatic gift. It is a retirement benefit received on the basis of eligibility and service record. In this case, one strong point from the employee's side was that the order of the appellate authority had not completely denied terminal benefits or superannuation benefits. If the order clearly says that the final benefits available to the employee according to the rules will be given, then why should pension be kept out of it? The court looked at this very interpretation. If an employee was removed, but at the same time it was also said that he would receive superannuation benefits, then the bank cannot later say that pension is not included in it unless there is a clear exclusion in the rules. Another argument from the bank side was connected to pension regulations. In many banks, there are provisions like Regulation 22, under which in cases of dismissal, removal, or termination, there is talk of forfeiture of past service, meaning the past service is considered wiped out. The bank tried to stop pension on this basis, but the court saw that here the punishment was under Clause 6B of the Bipartite Settlement, which contains the idea of removal with superannuation benefits. Therefore, every removal cannot be seen in the same way. Under which rule the employee was removed, what words are written in the order, and whether the employee is eligible for pension or not. All these things matter a lot. Now understand the real impact of this decision. A bank employee works for years. He runs his house from his salary, educates his children, repays loans, and relies on pension for retirement. If the job goes away because of some incident, receiving punishment is one thing. But if the law and settlement say that he can receive superannuation benefits, then stopping pension can be like giving the employee double punishment. The court understood this balance. Discipline is necessary, but legal rights are equally necessary. In this story, the employee's mistake or misconduct was not presented as small. Assault in a bank branch is not an ordinary matter. Discipline, respect, and safety are very important in any workplace. If the employee physically assaulted an officer, the bank had the right to take action. But the question was how far that action would go. Removal from the job was one punishment, but stopping pension would be valid only if the rules, order, and settlement together allowed such action. This fine difference often slips away from common understanding. Bipartite settlement is being called a sure-shot remedy for bank employees because it can provide legal protection to service benefits in difficult times. But it should not be understood as blind trust. Saying that it will get pension in every case would be wrong. If the employee did not opt for the pension scheme, did not complete the required service, or the order clearly denies benefits, then the situation can be different. So in every case, the facts, service length, punishment order, bank rules, and exact wording of the settlement have to be seen. Many employees do not read their service rules during their job. They do not even know what their rights are, what their status is in the pension scheme, under what condition gratuity will be received, how provident fund will be received, and if disciplinary action happens, what the appeal process is. This lack of awareness later becomes the biggest loss. A bank employee does not only need to work, it is also necessary to understand his employment documents. Appointment letter, service rules, pension option, disciplinary order, and settlement provisions. These are not just files, these are papers connected to the employee's future security. One more thing becomes clear from this case. The language of any disciplinary order is very powerful. If the order says that the employee is removed with superannuation benefits, then this line can later become a strong foundation for a pension claim. But if the order has dismissal, forfeiture, or clear language denying benefits, then the fight can be different. So whenever an employee receives a disciplinary order, he should not read it only emotionally and leave it there. He should take sensible legal advice and understand the meaning of every word. The importance of bank employees' unions and settlements also comes forward here. A bipartite settlement is not a document created in one day. It is made after long discussions between banks and unions. In it, a balance is created between employee welfare and bank discipline. The bank gets authority to take action on misconduct, and the employee gets protection so that in the name of punishment, his legitimate benefits are not taken away without legal basis. This is the balance of industrial relations. Now understand it in common language like this. If an employee has served for 20 or 25 years, is eligible under the pension scheme, and then is removed because of misconduct, but the order says that superannuation benefits will be given, then the bank cannot say that now everything is over. The employee can say that removal from the job is a separate punishment, but retirement benefits linked to my past service are a separate right. The court looks at this according to the rule book, not according to sympathy. This decision also means that banks will have to pass disciplinary orders very carefully. If the bank does not want to give benefits to the employee, then it will have to pass a clear and legally sustainable order under the relevant rules. And if the order talks about giving benefits, then stopping pension later can become difficult. That means this case is not just a lesson for employees, but also a warning for banks that clarity is very important in a punishment order. But there is also a big moral point here. No employee should think that he can commit misconduct because pension will be received anyway later. Fights, assault, abusive behavior, or gross misconduct at the workplace can ruin a career. After the job is gone, the legal fight can go on for years. Money, time, mental stress, family pressure, everything has to be borne by the employee. Reaching the Supreme Court is not easy. So this decision is protection, not a license. It is about rights, not permission to make mistakes. Today, when concern about job security is increasing among people, this case gives an important message to employees. If disciplinary action has happened against you, do not sit silently in panic. First, read the order. See under which rule the punishment has been given. See whether your qualifying service is complete or not. What is your eligibility in the pension scheme? What do the rules say about gratuity and provident fund? And if needed, take proper legal advice. Many times an employee loses his right only because he does not even know on what basis the fight has to be fought. The most important thing to notice in this story is that pension is not just money. Pension is an employee's dignity. It says that you have given years of your life to this institution. If you have made a mistake and have received its punishment, that is a separate matter. But your entire past service cannot be erased without the right legal basis. This very thinking shapes the court's interpretation in such matters. Provisions like bipartite settlement are important because they give a defined framework to both employee and employer. The bank can say that if you break discipline, action will be taken. The employee can say that action should happen only according to the rules. This is the beauty of law. The law does not side only with the employee, nor only with the employer. The law looks at documents, rules, eligibility, and fairness. And it was this fairness that brought the employee back toward the right to pension in this case.
If this video has taught you something new, or if you feel this information should reach more people, don't forget to like and share the video. Your small share can become valuable and useful information for someone else. If you have any questions related to this topic, or if you would like to share your opinion with us, be sure to write in the comment box. We read every question and suggestion from you, because your feedback inspires us to create better content. And if you want to keep receiving such interesting and reliable information about business, the economy, and the world in the future, then don't forget to subscribe to our channel GRT Business and also press the bell icon so that you get notifications of every new video directly. At GRT Business, we always strive to provide you with accurate, balanced, and reliable information. Our news and analysis are prepared based on information obtained from various news agencies, public sources, and public opinion. We make every effort to verify and validate each fact as much as possible. But in case of any possible error or dispute, the responsibility lies with the respective sources. Our only aim is to present you with a correct and trustworthy perspective so that you can understand any topic better.